Protection Commission should be an independent commission by having the appointment of the Data Commissioner done by the President and approved by the National Assembly. Members of the public and institutions that made their submissions on the Data Protection Bill currently under consideration by the National Assembly Committee on Communication, Information and Innovation say the independence of that Data Protection Commissioner is pivotal to the implementation and enforcement of the Data Protection Act. There was divided opinion on whether students involved in delinquency and minor crimes while in learning institutions should be granted the right to deletion of personal data records once they turn 18.
Institutions that presented their memoranda before the committee proposed that the removal of the Data Protection Commissioner should commence through a petition to the National Assembly, which, if satisfied, will send the petition to the President for the formation of the tribunal to investigate the conduct of the Commissioner and recommend action to be taken.
The Commission needs to be appointed by the President and not by a Cabinet Secretary, and that would allow for checks and balances that would ensure that the data, which is as valuable as public finance, is kept safe.
In July 2018, following a series of student unrest, the Director of Criminal Investigations issued a warning to all students involved in criminal activities in learning institutions. Using a hashtag on social media, #IFikeMaStudi, the DCI said that they have started profiling and archiving students who engage in riots in institutions, a move that will enable employers know the criminal backgrounds of students involved in such activities. The Data Protection Bill now provides for the right to deletion of personal data records.
And I think we are being unfair. Children must be given time to be children, and when they reach a certain age, that information must be expunged.
For example, a child data could be relating to maybe a health procedure that they undertook when they were a young child. It could be an organ that they got when they were a child. Now, when we say that at age 18 we are going to be forgetting all the child's data, then we shall be throwing out the baby with the bathwater.
That contention can be addressed, and it's very well addressed when you put an exemption, unless such information is in the child's best interest.
To demonstrate is not criminal. Yes, it's a right, and the system sometimes, the system can be against a mob, especially students. So we will ensure the right to be forgotten so that you are not denied employment.
Members also brainstormed on provisions touching on sensitive and special data, including those that limit fundamental rights and freedoms based on national security and public order.
While we agree with the importance of national security, it is critical that the grounds be laid out. And a place that the committee can look to is the Access to Information Act, which has 15 or so grounds under which information can be withheld in the national interest.
We are very keen on what's happening with the Huduma Bill, and since the government is processing personal data.
Inheritance sometimes can become clumsy when everybody wants to access information of the late, of the dead person. And sometimes we have an unprocedural way of sharing that information. I have seen a lot of public schools and even private schools and public schools advertising their ableness, their success, their victory, using information that is based on their children who are students in that institution. Some of them put even adverts in the newspaper, others they advertise using TVs and radio and quoting certain children who scored very highly, and in the process they also quote children who did not perform. And that to me is commercialization of private personal information.
Patrick Amimo, KTN News.